Yes, Sir James. Unlike
the ringtones round.
I'm not sure I've had 5 yet. But I think I've had 3.
no, I'm afraid, unlike council, we haven't returned yet to working with paper. hence the problems.
I was just saying before you came in, it's time to buy an iPad. 2 other things to deal with. The first one is I was going to describe it as the 5th factor, but that isn't entirely accurate. But it goes to the right constitutional body within our system under the separation of powers to make the decision about these changes. And my submission shortly in relation to that is that for all the reasons which will be very, very familiar to you, but which effectively centre on institutional competence on the one hand, the breadth of vision required to think about all the consequences of these changes and whether it's a good, bad or indifferent idea, and democratic accountability, which is the right body to start making decisions about societal changes in a sphere of complex social issues, that the responsibility is effectively the shared one between government and parliament. And I put it that way because we acknowledge, of course, that in certain respects this is a policy matter which could be dealt with by royal prerogative, but the broader issues will involve parliament, and they should, in our submission. But the key point is not whether it's government or parliament. The key point is that it isn't the courts. And I wanted to refer you to 3 authorities very, very briefly, one of which I don't need to go back to. I took you this morning to McConnell, the Court of Appeal case, you'll recall, and what it had to say about this subject, analysing the matter through the correct separation of powers prism we submit, institutional competence and democratic accountability in essence as the titles of the constitutional considerations. Paragraph 79 to 82, page 1391 to 1392. Don't need to go back to that. Secondly, Bellinger. I can't remember whether this morning I take you to, I better just check to be sure, 1106, if you would, in Bellinger on this topic. It may already be marked, but the question or the paragraph I wanted to flag was paragraph 37. Perhaps drifting into 38 and 39 and then onwards, but 37 in particular.
Can I just ask you, Sir James, this being a responsibility of the Home Secretary exercising the royal prerogative, there will be accountability to Parliament for the way in which the prerogative is exercised by her, will or not? And can I ask, are passports entirely a prerogative matter, or is there legislation in the area?
There is some legislation in the area. My Lord, actually I think both of my Lords will remember a case called XH, which involves control orders or T-pins. So there are some legislative controls over the withdrawal of passports or travel documents or matters of that kind. So there is parliamentary impingement in the territory.
I suppose the Begum case itself is an example.
Yes.
Of somebody being refused a passport, I think.
Yes, although that was deprivation of nationality, wasn't it?
Yes, it was.
At base. But purely on the passport issue, I think it remains the position that passports are a matter of the exercise of royal prerogative. So in the national security sphere, the Home Secretary was challenged, as in XH, on the basis that that prerogative power had been exercised unlawfully, was the allegation. But there has been parliamentary impingement on the turf, at least in the context of withdrawal or equivalent documentation.
Yes, thank you.
And of course EU law had something to say about that as well, as you'll recall. So there is a bit of a crossover. It's not quite as discrete an issue, if that was the purport of the question.
Yes.
But in any event, the legislative engagement in this sphere is obvious and is part of the consequential picture. But it's for that reason that I remind you of the statement of principle in Lord Nichols' speech in Bellinger.
It would be unreal to think that Parliament wouldn't have an interest in this. I'm going back to what my Lord was saying about the political accountability of the Home Secretary to Parliament.
Yes.
I mean, he would be subject to scrutiny if Parliament wasn't happy. It would, on what might be thought to be an issue of significant public policy, if there would be mechanisms whereby it could take steps as well.
Yeah, well, I agree with all of that. I mean, there's an obvious crossover there. So I suppose the real message coming out of that line of questioning is that the strict legal position isn't the entirety of the constitutional picture. And that's something which we certainly agree with, yeah. My lords, my ladies, the final authority I wanted to just remind you of in this respect. I think Ms. Hannett was anxious to convey a message. She was anxious to tell me that I got something wrong. Will you give me a moment? My lord, sorry, I was going to go, my ladies, I was going to go back to SC, if I may, and it perhaps bears on the discussion we've just been having. And paragraph 162. And in particular, the salutary message, as it were, at the end of paragraph 162, using as the vehicle for that for dissenting judges in JD. And that this is political is a relatively obvious thing. It goes to the line of questioning we've just been debating. But as my learned friend Ms. Hallett reminds me, there has been select committee interest in this area, as you'll remember from the papers. So our submission is that the sorts of decisions that we are dealing with are paradigmatically governmental/legislative, and that both of the principled underpinnings for the separation of powers concerns that you're very, very familiar with are in play. Can I then turn to Article 14 as the final topic? And I'm going to take this again very, very briefly, if I may. The first point to note, or the first submission to make, if I may, on Article 14 is that it would be very peculiar indeed, we submit, in a context such as this, in which you could have a different position if only you cast your complaint in Article 14 terms. The context of the Article 8 claim involves considering, balancing all the various factors that are in play from Hammerleinen. It involves balancing all of those factors and deciding whether there is a positive obligation to introduce, say, X on the passports. And if the position is that balancing all those factors together, the answer to that question is that there isn't a positive obligation, it would be very peculiar indeed, we submit, if not incoherent, for a different answer to be yielded if only you were able to rely upon the difference which the absence of the positive obligation has created, if that makes sense. I mean, of course, Article 14 can introduce a different analysis in some circumstances, but that is a potentially unusual feature, perhaps, of this sort of situation. And in any event, we submit, perhaps alternatively we submit, that even if you can get through the door, the analysis on justification of the difference in treatment, and in particular margin, consensus and all of that, must be the same.
I took it from the way you presented the case this morning that you were not saying there was no positive obligation.
I was saying there's no positive obligation to put X on the passports and to
In general,
introduce that.
there is a positive obligation, which is expressed in very abstract terms.
Yes, well, at that level of
perhaps that's
generality.
the difference between us, but your focus is justification.
Yeah. Well, the justification we respectfully submit, margins should be the same, the analysis should be the same. The message from the Supreme Court in SC is, in particular, that's the important bit, because in Steinfeld, as I noted this morning, both in the Court of Appeal and then in the Supreme Court, the approach was very much to take the view this is a suspect category or something like it, and therefore the margin is narrow. We now know that that isn't the correct analysis. The correct analysis is to balance the various features, and we saw indeed that the lack of consensus and margin and so on can trump, in effect, even the involvement of that suspect category in certain circumstances, and was treated as doing so in the context of gender identity by the European Court in Hammerlein, amongst other things.
Yes, it was certainly on a different basis, the case in the Court of Appeal, from when it got here.
Yes, it was. It was. And Steinfeld itself involved a very different context. I don't need to remind my lady of that, but the context in Steinfeld was remarkably different for this reason, if no other, that in Steinfeld, as you recall, the discrimination which caused the difficulty had effectively been created by the enactment of the primary legislation which caused the difference to arise. Right. And so it was that caused all the drama. We've got nothing remotely comparable here. But my respectful submission is that even if there can be coherence in finding no positive obligation under Article 8 and then still going on to Article 14 to achieve a different result, when you get to justification, the essential justificatory factors and the approach to them is the same as under Hammerleinen, and that is the same as the directly binding authority of SC, which I remind you was an 814 case. So it was a discrimination case. Of course, the context was very different.
My recollection is that Steinfeld was a rather odd case in that the differential treatment of same-sex couples from different-sex couples was admittedly anomalous.
Yes.
And
it was pure time.
And the government's argument, as I recollect, was we'd like more time to decide whether to eliminate the discrimination by going down one road or by going down another road.
Yes.
But there was admittedly discrimination.
A terrible argument in context, obviously.
Well, it's a different argument at any rate from the one in the present case.
It is. It is. That's perhaps the important point. But yes, and we don't have any analogue to the creation of that discriminatory setup through the enactment of the primary legislation, yes. Albeit that was done.
Yes, I mean, everybody was agreed in Steinfeld that the status quo
was not good,
was unsustainable.
Yes. Oh, yes. So there are those features that distinguish it. But as I say, taking the point of principle about justification and how all that works, all the same factors play in and lead to the same outcome, we submit. So those are my submissions on Article 14. And unless there are further questions for me, I can assist further. Those are my submissions. A little bit before time.
Say anything about social reality? Is it paragraph 66 again? So discordance between social reality and the law.
In Hammerleinen, my lady, do you know?
It's paragraph 66. Will it be 747?
Thank you.
Yes. Well, my lady, I hoped I'd addressed that under the four topics that they then come to deal with under paragraph 67.
Yes.
I mean, I think the only discordance between social reality and the law in Melanie Friend's submissions then fed into those points about NHS and trans people and the contrast. But my submission, standing back, as you know, in relation to this case, is that there isn't any discordance between social reality and the law, and that's to some extent a question begging way of looking at it, because you then go on to see consensus and you go on to see what the social reality actually is. But I don't think I've got a separate topic to deal with that.
Fine. So you read that as a reference to consensus, or rather the lack of consensus within society.
Well, that's in part what it is, because you've got to work out what the social reality is, which is the basis. And so to some extent, you're thrown forward, is perhaps the way I'd rather put it, into the identification of the particular factors.
In 67.
In 67, yeah. It's a framing point, rather.
Yes. Thank you. Sorry, it was 748. Pardon.
Yes, 748, just by C, between B and C.
Do we get anything on Article 14 from Hämäläinen? I'm just looking forward in the judgment, because there was an Article 14 read with Article 8 complaint there, but it seems to have gone off on a different basis. Sorry, I'm looking at page 756.
Yeah, it looks like it was the contrast that was being drawn was different. And they held there wasn't sufficient similarity in contrast.
But so that's not reasoning you rely on. We
No.
just put that to one side. Okay.
It isn't.
Well, it's interesting in the light of your submissions that paragraph 109, dealing with, I think, the Article 14 point, is in remarkably similar terms to the earlier paragraph that dealt with the positive obligation.
My lady, yes, that's a fair point. I should have drawn attention to that. But no material distinction, and perhaps as importantly, no material distinction between the nature of that analysis and the analysis of the Supreme Court in SC. Yes, and then you see the actual ground on which they disposed of it on the basis of no proper comparison in 111 and 112.
Mm-hmm.
Thank you very much, Sir James. I don't think we have any other questions for you.
Grateful.
Ms. Gallifant.
At the rate the clock is going, I will have completed my submissions before I was intended to start them this afternoon, which we all may be grateful for.
No need to apologise for that.
I will not, of course, be repeating submissions, just to take a few, if I may, points in reply to certain points made by Sir James. Can I start with the SC case and just emphasise a paragraph that Sir James did not, which is paragraph 142, just before the paragraphs to which he directed this court in particular. And in particular, the point that is made there emphasises at the bottom, in relation to the context of Article 14, the fact that a difference in treatment is based on a suspect ground is particularly significant, and it refers to various recent cases, like many earlier, as indicating the general need for strict scrutiny, focused on the requirement for very weighty reasons, where the difference in treatment is based on a suspect ground, such as sex or birth outside marriage, unless the issue concerns the timing of the reform designed to address historic inequalities, where a wider margin is likely to be appropriate. We say that that situation does not arise here for the reasons that I articulated yesterday. The government, as the Secretary of State, has never accepted that this is an issue of timing, because the Secretary of State does not agree that there is any interference or positive obligation. So this cannot be a timing case on the Secretary of State's own case. The second point I make in relation to SC is at paragraph 144, and this is the separation of powers between the judiciary and the elected branches of government, we emphasise the final part of that paragraph, which Lord Neuberger observed in RJM, that there will come a point where the justification for a policy is so weak, or the line has been drawn in such an arbitrary position, where even with the broad margin of appreciation accorded to the state, the court will conclude the policy is unjustifiable. We say we are firmly in that position. On the point made by Sir James about if this court were to accede to our submissions in relation to a positive obligation under Article 8, then it would mean effectively that every other Council of Europe state would equally have to adopt ex-passports. We submit that that analysis isn't quite right. It doesn't reflect what would actually happen in terms of Strasbourg procedures. If another case is brought in a domestic situation, then that state can argue that actually different circumstances apply. And even though a positive obligation was found in the United Kingdom, no such obligation should be found in the Czech Republic or Hungary or wherever it might be. If that gets to Strasbourg, other states will be able to intervene, and they will be able to make the points that they wish as to differences in the factual context, in particular in relation to the burden on the state or the burden on the appellant, as to why no positive obligation should arise. Other states can join at that point, and if the Strasbourg Court considers that there actually should not be, as it were, a positive obligation affecting all states, then it will and can say so. So we don't accept that one can simply jump from saying, because there is a finding of a positive obligation by this court, it follows that every other member state of the Council of Europe is required to provide for ex-passports. Can I move to the factors? Sir James started with the question of whether there are sensitive moral or ethical issues. I make 2 points in this respect. The first is that, as identified in Hämäläinen, is part of the analysis going to consensus. So it is not a freestanding factor. What Hämäläinen says, page 748, is that where there is no consensus within the member states of the Council of Europe, either as to the relative importance of the interest of stake or as the best means of protecting it, particularly where the case raises sensitive moral or ethical issues, and then the margin will be wider. So one sees there, it is not identified as a freestanding factor. It is an element that goes to the question of consensus. In other words, one anticipates by the Strasbourg Court that there may be less consensus if there are issues of sensitive moral or ethical issues that arise. But it is not, in and of itself, a factor that goes into the mix when we are dealing with the factors, in other words, the impact on the appellant and the impact on the state. My learned friend repeatedly referred to there being social issues engaged at this point. The reference to sensitive moral or ethical issues does not include social issues. We say importing that concept as to, as it were, controversial social issues, it is not correct or appropriate in this context. It is not done in Hämäläinen. It is not done in SC itself, just to note at paragraph 160, where the point is made that it is sensitive moral or ethical issues, not social ones. Sir James suggests that there are
sorry, just would you say that, how would you identify a social issue which is not a sensitive moral or ethical issue?
Well, a social issue might go to the sort of public interest question that might not be moral or ethical. The point I'd give by way of example in relation to same-sex marriage. One can easily see whether that raises a moral or ethical issue because of the nature of same-sex marriage. There may well be other controversial issues, but that don't raise moral or ethical issues, in principle. And my lords and my ladies have already had my submissions on why we say this particular case doesn't raise such issues. But the sensitivity of the moral and ethical issues, primarily relied upon by the Secretary of State, are the issues that Sir James puts would need to be considered, as it were, beyond the remit of this challenge. In other words, he does not place his the gravamen of his claim on sensitive moral and ethical issues as going to ex-passports, what the Secretary of State says is that the sensitive moral or ethical issues arise in the wider context, that is the question of pensions, for example, and that's where there might be sensitive moral or ethical issues. Now, that is predicated on, as is a number of the aspects in relation to administrative coherence, that is predicated on there being, as Sir James put it, associated issues that would need to be considered. Can I just, if I may, take the court back to Kate O'Neill's evidence, which was before all the courts below, and is before my lords and my ladies at 437. And at 437, under the title, The Need for an Administrative Coherent System for Recognising Gender Across Government, what Ms O'Neill says is, at paragraph 57, that introducing X markers could have wide-ranging implications for other areas of government if, as a consequence, service provision and legislation that governs it had to change. There would be questions of cost and proportionality. Continues at paragraph 58, for example, in relation to other government departments. It says the government departments to ascertain some of the potential ways that legislation and service provision might have to change to accommodate a gender identity other than male or female. Again, paragraph 59, so far as the Government Equalities Office is concerned. Far-reaching changes might be needed to the Act should a third gender become more recognised. And I could go on. That the point is simply, this is speculation rather than there being any associated issues that would need to be considered.
Well, is that altogether fair to Miss O'Neill? Because surely in government, the government has to consider across all departments the implications of any action which may affect those other departments. I can simply say that from the Law Commission, as I recall, whenever one had a report with a set of recommendations, it had to be examined cross-departmentally. It wasn't simply a question for the one sponsoring department. And it's a question of efficient government and joined-up government, I think it was called this morning.
I think it was. My lady, the point that I'm making is that there is no necessary consequence of introducing the option of an ex-passport. It can be done in isolation. No one has suggested it cannot be done in isolation. The Secretary of State's position is it is preferable not to do so on the basis of administrative coherence, but it can be done in isolation. No legislative time is required for it. It is the royal prerogative. It has not been suggested that there is a need to amend any piece of legislation, secondary or primary or other. And that's why we say that when one looks at the evidence of Kate O'Neill, as a matter of, as it were, joined-up government, I might think, well, now should we do something else over there? The government's entirely entitled to consider, should we do something else over there? But what it's not entitled to do, we say, is rely on other things happening. In other words, there would be a necessary consequence. If you amend something here, something else will change there. So that's the position we say in Bellinger and Bellinger. If the court had acceded to the appellant's arguments there, to read man and woman in a way that man meant man, as it were, or person whose original sex was woman, and the turn it around, then there would have been consequences as a result of reading the legislation in that way. Here, that is not right. There are no necessary consequences, repercussions, or the like. Simply, it is a matter of choice for the government as to whether it wishes to take steps in other contexts. Now, the reason...
So the difference between you is, you say that it's therefore not to be taken into account unless it's a necessary consequence of the X marker. Whereas what I think Sir James is saying is the government wants to approach this in a more holistic way, and that is within its wide margin of appreciation, and that we should respect that as the wish of how the government wants to deal with it.
I didn't understand Sir James to be arguing that that falls, as it were, that desire is within the wide margin of appreciation. As I understood the Secretary of State's arguments, it is that that is a legitimate aim for the purposes of assessing, either if you look at it as an interference case, where that interference can be justified, or if you're looking at the positive obligation case, the burden on the state. So, as I understand, what the Secretary of State says is, well, there's a huge burden on the state because, look, you'd have to do all sorts of other things, potentially, and look at all these other contexts, pensions, the Equality Act, and those sorts of things. But we say, in this part of my submissions that go to the question of sensitive moral or ethical issues, one can't say that this challenge raises such issues because it doesn't follow that there will be any change to any other part of law or policy as a result of this challenge. So one can't hold up a spectre of sensitive moral or ethical issues arising in some other context. One has to look at this challenge and this context. And my Lord and my Lady had my submissions on why I say there are no such issues in relation to ex-passports, the measure itself not being controversial, and the long-standing principle since Van Cook of the fundamental importance of gender identity.
Can I just raise with you the extent to which that submission is compatible with the Hämäläinen judgment at paragraph 70 to 75? So this is page 749.
Sorry, let me... Yes.
In Hämäläinen, the applicant said, just deal with my case. I'm in a very unusual situation. And I want to preserve my marriage. But the court at paragraph 70 says, well, in practice, we don't think it's feasible to limit the claim in that way, and they consider that it raises wider issues in relation to same-sex marriage. And then reading on at paragraph 75, the court, having identified a margin of appreciation, partly based on that, says it extends not just to whether to enact legislation concerning legal recognition, but also the rules it lays down to achieve a balance between competing public and private interests. Now, might it not be said that both those passages don't suggest that there's this strict relationship of necessity of change that you seem to be submitting is the necessary predicate for administrative coherence to run as an argument?
Well, I wouldn't accept that, because what Hämäläinen considers, and it considers the issue from two different perspectives. So what is clear that the applicant in Hämäläinen wants to be able to do something that they're not permitted to do. And the court starts by considering whether there is a freestanding right to same-sex marriage. And that's what one starts by considering at 71. And it moves on to consider the slightly different question from 76 onwards.
But forgive me for interrupting, but I was directing your attention to paragraph 70 in particular, where one sees what the applicant was advocating. Yes. So they're not advocating same-sex marriage in general. They're saying, I've got a small problem, or please deal with that. You don't need to worry about wider implications. And the court seems to be rejecting that as an approach.
Well, because it couldn't limit it to that particular individual. It would say that a person who was effectively then condoned to be in a same-sex marriage, people who were in the same position as the applicant would also effectively then have the right to be in a same-sex marriage. In other words, you can't say it's just an obligation in relation to me. That leads to a situation where two persons of the same sex could be married to each other. So that isn't, as it were, a difference between saying, I mean, we would say the difference between an ex-passport and pensions, which we say there is no direct significance between them. What the applicant is seeking is effectively a right to same-sex marriage, as it were, by the back door, and that's what Hämäläinen thought couldn't be done.
Well, so, she sought to characterise what she wanted as a continuation of her marriage. She just wanted to remain married.
Well,
and it would have been possible, theoretically, to carve out that class of case and say, yes, people who are married, change sex, should be allowed to continue in that married relationship.
Well, people who were married and changed sex were allowed to continue, as it were, but she couldn't have the civil status recognised. You see, because it's a precondition to the recognition of civil status that the marriage is either dissolved, there's divorce, or transferred to be a registered partnership.
Right.
So that's why I think there are two parts to the court's reasoning in relation to the argument there. The second part is in relation to the precondition, and that's the part from 76 onwards. So that's the part in which they say actually there is a fair balance struck, because the precondition, in other words, in order to get your civil status recognised in your acquired sex and acquired gender, you have to do one of the three things that are set out in relation to, sorry, just going back, the Finnish law position.
But it's paragraph 69 sets out the parameters of the problem, I think.
Yeah, I think it's slightly more, but sorry, I've taken it back. But there are the different options. Sorry, it's paragraph 76 itself I was thinking about. There are the different options, which makes it clear at 76, nothing prevents the applicant from continuing her marriage. You see, so that was an option. The applicant could remain married, but if the applicant remained married, then because of the precondition, she wouldn't get her civil status.
You mean her civil status as a woman?
Exactly.
So she could remain married as
Yes.
long as she didn't then say she was a man? Sorry.
It's the other way around,
The
I
other
think,
way
isn't it? Yes. You had a moment of confusion,
Right.
but you confused me for a minute.
She couldn't change her status from her original birth gender.
She couldn't change it to
being a
acquired
woman,
gender if she remained married.
if she remained married.
Exactly. So that's the point. So an option was to remain married, but
Right,
that wouldn't have...
but not with the identity that she wanted.
Exactly. And that, the court finds, is acceptable and doesn't give rise to an issue from a positive obligation point of view because of the close proximity between the status of marriage and the status of registered partnership. So that's the analysis in 76. But going back to the point my Lord puts to me, which is, why isn't Hammerleinen also concerned with a wider issue? Because it's concerned with the scenario whereby one either gives up marriage or turns into a registered partnership. It is not a knock-on implication. It isn't, as my Lord repeated to me yesterday, the domino effect. It is that the position is, if there is not a right, a freestanding right to same-sex marriage, which there isn't, because that would be the position that effectively this individual would be in, then the court goes on to consider, well, if there's not that freestanding right, is it actually the precondition that you're no longer married but you convert to a registered partnership in order to get your civil status changed to your acquired gender, is that disproportionate effectively? And they say it's not disproportionate because of the proximity to it. But there's no separate policy context than marriage. As it were, it happens to be that this particular individual wants to remain married but wants to have their civil status. And those two concepts are incompatible under the Finnish law, and they find the Finnish law is not in breach of the positive obligation.
Right,
so I don't accept that this goes further in the way that Sir James's submissions do go further to say, there is a necessary knock-on effect from an ex-passport to marriage, for example, because that isn't the case. Now, if you had to, as it were, not be married to get an ex-passport or something like that, then we'd have the same position as in Hammerleinen. But there is no connection between the status of a person holding an ex-passport and their status in terms of whether they can or can't marry. So they're not logically connected. Whereas in Hammerleinen, they were inextricably connected.
All right, thank you.
I'm sorry, I know that was a longer answer perhaps than it deserved, but I'm sorry to go around the houses on someone. But that's why I don't accept that that's, as it were, a supporting factor in relation to Mr. Eadie's arguments on that. Can I just pick up, in fact, also a point that was put by my Lord Sales to Sir James. If one is only seeking an unspecified marker on a passport, does that, as it were, move away from the appellant's status as being a suspect category? My Lord Sales, we wouldn't accept that at all. I've already referred to the Van Cook line of authorities in terms of the fundamental importance of gender and gender identification. The Secretary of State, of course, accepts now that gender identity, as in non-gendered in the appellant's case, falls within Article 8, and Article 8 is engaged. The Secretary of State also accepts that the appellant has to misrepresent the appellant's gender when making an application for a passport, and that was accepted in terms, that there was a false representation when the appellant does so. And we emphasise again the declaration on the passport form, which makes it clear that false or misleading statements could lead to criminal sanctions. So we say that we fall firmly into the suspect category because of the very nature of the declaration that needs to be made. In other words, the appellant has to misrepresent the appellant's gender identity in order to obtain a passport. That is resolvable by the simple deployment of an X marker instead of requiring a misrepresentation, a false representation. So we don't accept at all that just requiring or seeking unspecified on a passport moves the analysis in any way away from the suspect category. On the contrary, we say that they are inextricably linked. It is because of the suspect category that the X marker provides the answer to not making a false declaration. Can I deal relatively shortly with consensus? My Lord Lord Jones suggested that there might have been some hint at a customary international law obligation. It is neither the position of Human Rights Watch nor ourselves to suggest that such an obligation arises. We do, and I'm grateful to the Human Rights Watch people, simply though, to take a step back from the question of foreign law on this point. My Lord Reid might remember, in fact, an article he wrote for Law Quarterly, and perhaps if I can just read it out, it's of no, as it were, sorry, James, let me give you that. It's simply, we are not saying that one has to follow, and we couldn't say it, the continuing international trend. One is not obliged to do that. But we do say it is helpful to think about it in the terms that Lord Reid did in relation to this, which is, it's not a comfort blanket, foreign law, but it's normally a source of ideas and information that can assist in focusing issues, enlarging perspectives of a problem, improving the quality of reasoning, and ultimately placing the court's decision on a more persuasive footing. So we say that that is absolutely central to why we say, why is foreign law helpful in this context? And we say it's helpful for exactly those reasons articulated by my Lord Reid.
Is that one of the authorities?
It's not, and I'm so sorry. I was handed it a moment ago. So can I would hand it up. We don't any pieces of paper, do you?
It might just be useful to have a
we
reference.
can send it through, or in fact, I might ask the
Was it something like 2008 LQR?
That's excellent. It was indeed 2008, and it's Foreign Precedents and Judicial Reasoning: The American Debate and British Practice.
Thank you.
And I'm most grateful to, I think it was Ms. Jones, who was familiar with your work. Yeah. I'm very grateful, my Lord. Can I move then to the positive obligation in the article, in particular the Article 8.2 analysis? I've made quite detailed submissions as to why we say that the approach, whether it's a negative or a positive case, is similar or comparable, as it's put in the authorities. And we have always advanced our case on both a negative and a positive basis. The starting point is that acceptance now of engagement of Article 8 does give rise to the right to respect in principle. I have always fully accepted that then in order to, for that right to bite, in order to have teeth, then one either has to show interference for a negative obligation or that a positive obligation arises which the state has failed to fulfil. We say that the fact that our focus is on a passport cannot turn this question into an implementation question. And on that, we then emphasise that when one looks at Hämäläinen itself, and I wonder if I might take it back, and my Lord Sales very helpfully went back to the summary of the Chamber decision when asking Sir James about which of the, of course, exhaustive and restrictive factors, as identified as legitimate aims in 8.2 rather, he was relying upon. Now, In that context, my Lord went back to paragraph 36 of Hammerleinen, which refers to the Chamber's judgment at page 741, in which the Chamber found the facts of the case fell within the ambit of Article 8 and within the scope of private life. There'd been an interference, and then the interference was in accordance with the law, because it was prescribed by the Act, and had the legitimate aim of protecting health and morals and the rights and freedoms of others. Just to put some colour on that context, when one deals, when one looks at the background to that, at paragraph 18, one sees the Supreme Administrative Court's decision, and one notes that there, at paragraph G on page 738, that the argument there was that under Finnish law, not possible for the persons of the same sex to marry. In such a case, they could enter into a registered partnership. Legal and economic consequences, it's essentially comparable. And then the point is made there that the question of transforming the institution of marriage into a gender-neutral one brought significant ethical and religious values into play and required the enactment of an Act of Parliament. We emphasise there that that is because of the nature of the institution of marriage. In other words, it has significant ethical and religious values in play. And then going back, if I may, to paragraph 38, setting out the Chamber judgment against that background at 741, the Chamber judgment noted that the balance of the rights, the two sets of competing rights, included the applicant's right to respect for her private life by obtaining a new female identity number and the state's interest in maintaining the traditional institution of marriage intact. So that is where the ethical and religious values are in play. So when one looks at why health and morals was engaged, one can see there that it's because of the ethical and religious values in relation to the institution of marriage. It's also relevant when considering the rights and freedoms of others that in that case the position was that the partner of a person in the position of the applicant at Hammerleinen would have had to consent to entering into the registered partnership. So one can easily see why there is a third party, as it were, interest clearly at play when one is dealing with an institution of marriage and a requirement that that institution be converted to a registered partnership if, or there'd be divorce, let me put it that way, if one of the partners wishes their acquired gender to be recognised as their legal status. So one sees there readily why the rights and freedoms of others are engaged.
They're also engaged in same-sex marriage as is developed in the case law as to whether then it's open to ministers of different religions to refuse to conduct weddings, or
indeed.
Registrars to refuse to conduct weddings if they're...
It is, and that's part of the series of exceptions that Amalia I've referred to in relation to the Gender Recognition Act, and those exceptions that, for, as it were, not all purposes is the person, as it were, considered in their acquired gender, and that is exactly one of those exceptions that I think is referred to in the paragraph in SC that I gave the reference to yesterday, but entirely. But the reason for that, we say, is because it is directly connected to the role of the minister in conducting the marriage. It isn't that there is another policy at play. It is the policy of marriage. And the institution of marriage and upholding it is, of course, recognised as being a legitimate aim for the government of Finland in Hammerleinen.
What about other people's Article 14 rights? So if someone sees a particular group has been given, let's say, what they regard as preferential treatment, and they say, well, that's unfair and in breach of my rights under Article 14, can that be a basis on which freedom of the rights, rights and freedoms of others comes into play in favour of the state seeking to treat people equally where it can?
If I may, I want to distinguish between the positive obligation under Article 8 and under Article 14, because I do say that the legitimate aim issue is slightly different. But answering my Lord's question, let's posit a case in which the government considered that the only appropriate set of... Well, it accepted our claim. It said persons who are non-gendered and others who are non-binary, so the affected class, as we've defined it and as Human Rights Watch have defined it, those persons should be entitled to an X passport. A cisgender person, let's assume that the policy doesn't include cisgender persons, as Maria Rose put to me yesterday, a cisgender person could bring a claim and say, well, I'm not allowed to have an X passport. The government would clearly be able to justify that on the basis that that is a cisgendered person. It's the implementation of a right accorded to persons who do not identify in the binary as either male or female. The cisgender individual identifies as male and female. There is therefore no relevant difference in treatment because the cisgender person can obtain a passport in their gender that is congruent with their gender. So that is the difference in treatment that is accepted by the Secretary of State arises in this case. So, my Lord, the government would be able to justify that because there's no, well, not justify, it wouldn't get to the point of discrimination because the position would be different. There would be no comparable as well, relevance.
But what I had in mind was, isn't the government allowed to check across the range of governmental action whether to give the applicant the treatment that they want it to deal with their case might give rise to problems of other people being able to say, well, if you're going to treat them in that way, but not me, that is going to involve a breach of my rights under Article 14.
Well, we would say necessarily not because of the way in which the discrimination position is put. So it isn't necessary to consider the rights of others under a potential Article 14 claim because the rights of persons who weren't part of the affected class...
Sorry, I was seeking to focus on Article 8.2, but the question is, under Article 8.2, where the rubric is rights and freedoms of others, does that not include the Article 14 rights of others?
Well, I'd say it can't because there aren't Article 14 rights of others in that context in relation to the passport.
Okay, thank you.
And I note, of course, the Secretary of State has never suggested that there is any right of others at play. The Secretary of State's position is not in relation to the passport policy at all. There is no evidence that the passport policy would give rise to any issues. Kate O'Neill's evidence is entirely directed at other areas of policy across government.
I had understood Sir James's submissions where he was talking about, well, if you do this, you'll create comparators which will lead to problems elsewhere, to be directed to what would happen potentially under Article 14 if the law is changed in this particular way. I
have very much not, I'm afraid, understood them, and it's my error if I hadn't understood them to be that way, because Sir James is very much not focused on Article 14. I had understood always that argument to be, if you give someone an ex-passport, the next thing they'll want is a pension and a preferential treatment or less preferential treatment or whatever else it is in a different context. I have always understood that to be the Secretary of State's position, and will be correct, no doubt, if I've misunderstood that.
But that makes the point, doesn't it? I mean, that's sufficient for his purposes to say, if we give the X marker in relation to the passport, it will be argued in other fields of life that there should be the X marker, and that will involve resources and wholly different considerations, and we ought to be able to think about that and decide what that impact would be across the board before we make any decision. And that's where the comparator point arises.
My lady, I recognise the practical desire on the part of the Secretary of State not to have further litigation or persons seeking to obtain either a correction of an inequality of treatment, as they might argue it, or a positive obligation in another context. I can absolutely understand why the Secretary of State doesn't want to be going down that route. But to an extent, that ship has sailed at the point where a non-gendered person's gender identity has been recognised as engaging Article 8. So anyone can already, I'm so sorry, my lady, to interrupt, anyone can already start bringing those challenges following the decision of the High Court upheld by the Court of Appeal. Because any person can say there is a positive obligation as a result of my gender identity, for you to do X or Y, that's a bad example, to do A or B in the context of pensions or something like that. That is already there. That's why I say that ship has sailed. I'm so sorry, my lady.
I'm sorry to interrupt you, and I didn't mean to.
It was me.
The point is that once you give recognition to the X marker, then it will be argued that it should be used in other places. And just on a point of accuracy, the positive obligation is not an obligation in relation to the passport. If you look at 71 of Goodwin at 721, the positive obligation is to ensure that the rights of the applicant, in that case it was a post-operative male to female transsexuals, to respect for the family life. So it's as broad as that.
We would say it isn't. That isn't the positive obligation we've ever argued for. And that's the point that Sir James has always made, which is because, and I think Mr. Carter, we've argued for a very modest positive obligation. We aren't going that far. Now, my dear, I entirely accept, if we were arguing for a Goodwin-style positive obligation, that's it. Every aspect of life that's based on civil identity, civil status, would be up for grabs, just as it is post-Goodwin. So you get on to all those other questions about pensions and the like. I accept that. But we are not arguing for that here. I'm so sorry. I will...
I'm sorry. I know you tailor the case to the passport and the X marker, but once the state accepts the positive obligation in Area A, it's going to be argued that they should accept it in Area B. And the positive obligation is a very, very broad one in 71 of Goodwin. Well, it's all aspects of life, really.
But not the obligation that we argue for here.
Well, that's the way you put the case, but the impact of the court's judgment acceding to that may be that the positive obligation is as broad as it's put in 71.
That's certainly, by my understanding again, never been the understanding of the Secretary of State, that the effect of the obligation we seek would mean that the obligation would have effect in other areas of policy. The Secretary of State's position, and Kate O'Neill's evidence, is that the government should be entitled, that's the way they put it, to consider whether there might be need to change other pieces of policy so that there's a coherent position. Now, we don't, of course, accept that as a point of principle, but we are not arguing for a Goodwin-style positive obligation.
Well, maybe not, but the court has got to decide the case on a principled basis. So it has got to define the positive obligation which it's accepting, and it can go no further than Strasbourg, whatever it wants to do, and that is an obligation put in very broad terms. You can't have a bit of it and then say I reject the rest on a principled basis.
We would say we can, because that is not least the approach that's taken in cases leading up to Goodwin. So, my lady may recall, there are the cases such as Rees and Sheffield and Horsham. Some of the claimants there asked for much more limited positive obligations, such as a positive obligation to change the birth certificate rather than a positive obligation for all rights generally. And that's a point that's made. It might be worth going just to Sheffield and Horsham, just to make that point good, my lady. I'm conscious that I perhaps didn't deal with it in any length yesterday.
Do bear in mind that you don't have much time.
No, in that... I won't. If I will, I'll just give you the references in a moment to those paragraphs. Can I just deal then with why I say we are entitled, we say, to ask for a smaller positive obligation than the wholesale, the all singing, all dancing obligation. There is no difficulty. We are asking for less than Strasbourg has done in the case of Goodwin. But the key point we say in relation to coherence is not just that there is no legitimate aim that the Secretary of State can point to, and that's emphasised by Sir James's emphasis that when you look at the final sentence of Hammerleinen at 67, the public interest needs to be balanced. That doesn't mean you can add in any old other factor that you like. That means the public interest that's identified already in 67 needs to be balanced against the interests of the applicant. When it came to the question of surgery, the argument was in Goodwin, and we put it, which is there is an existing incoherence. It's the social reality point. My Lady Arden puts the social reality is the inconsistency, the discordance between social reality and the law. But in that context, Sir James accepts that the argument cannot be in principle that if there is one form of respect, it follows that the wedge has been put in and all other things must follow. We say that that is a complete answer, then, to his arguments on coherence, because if he accepts that, it cannot be that if there's one form of respect, that the wedge has been put in and all other things must follow. That is what we say as well. So we agree that if you say there's respect in one area, here, ex-passports, it doesn't follow that there should be a positive obligation in the context of pensions or prisons. We do say that it is notable that the Secretary of State's position on the existing transposition, there's a pause between those two words, the Secretary of State's position remains that inconsistency and incoherence, in other words, a trans person can obtain a passport with an M or an F that's not on their birth certificate without a gender recognition certificate by virtue of a medical letter. We say that that is inconsistent, and the Secretary of State has never sought to correct that. But the Secretary of State today still relies upon the Court of Appeal's indication that actually that inconsistency, that incoherence in the current structure is all the more reason to look at things more generally. We simply note that there has been nothing in the intervening period, nothing in any of the reviews, and nothing in the current review identified by Mr Entwistle in his second witness statement to suggest that the Secretary of State considers it even necessary to review that position. And there has, of course, been the very recent consultation on the Gender Recognition Act. There was no suggestion that trans persons shouldn't be able to obtain a passport without a gender recognition certificate or in some other way. There is nothing to suggest that that will change. So for the Secretary of State to say, actually, we support and agree with the Court of Appeal's conclusion that administrative coherence is required, not least to correct the existing incoherence as far as it comes to trans persons, well, that isn't factually the Secretary of State's position. And I'm not quite sure we can add up all the different numbers of reviews. We might be on number 8 or 9, but the current review still doesn't consider that. Can I deal very shortly with security? I'm so sorry, my Lord, if I may. I'm not quite sure what the actual time is, but well, maybe past it.
It's 3 minutes past.
Is it? Can I deal very briefly?
You'll have to have a rapid canter over the remaining
I'm going to
offences.
skate rather than just canter. Security and identity. Fraud, there is no difference between a trans person who doesn't have a gender recognition certificate and an ex-person, a person seeking an ex-marker. In either case, simply the passport office looks at the birth certificate. Travel at borders, we note and emphasise that there is no evidence of any issues arising from the use of an ex-passport at the UK borders. Indeed, Human Rights Watch make it clear there is no evidence of any issues arising at any border. The suggestion that other countries have taken risks in relation to the issuance of passports, well, once it's accepted that this country accepts ex-passports, as it were, this country also takes the risk of admitting those people. We have no evidence that ex-passport bearers are not admitted. They are. My Lord Reid asked a question about the ICO in this context. It might be very helpful, if I may, just to go back to the Judge at First Instance's judgment, page 310, if I can give my Lord the reference. Sorry, I might have given you completely the wrong reference. It is 310, paragraph 42. The reason why those standards matter is because the UK is a contracting member state of the Convention, the Chicago Convention, and that the ICAO is effectively the expert body which has been undertaking the highest practical level of uniformity in practice to relation to, for example, including passports. So that's why, and it's a helpful paragraph 42 and 43 distillation of why the ICO standards matter. So far as the individual is concerned, one very short factual point. It was suggested by Sir James that most of the time a person looking at a passport wouldn't look at the page with M or F on it. One could all check one's passport at home. The M or F appears right next to the photograph of the individual underneath the date of birth. There isn't a separate page for M or F. The constitutional position, we say, of course, in Bellinger and Bellinger, a declaration of incompatibility was granted, and it is a different position, we say, because we are not seeking the court's rewriting of male and female with its particular consequential concerns. Article 14, my learned friend says, if it isn't a positive obligation, it's very peculiar for there to be a different answer under Article 14. We don't think that that's right as a matter of principle. Article 14 analysis is inherently different to Article 8. We accept, for the avoidance of any doubt, we accept that administrative coherence can be a legitimate claim. It's not a point made by the Secretary of State, but I make it clear it can be a legitimate aim in the context of Article 14. One sees that at AL Serbia, for example, page 959 at paragraph 6. The original policy had a legitimate aim to improve the system of asylum control in the general public interest. So we accept that for the avoidance of any doubt. But that's because Article 14 doesn't have an exhaustive and restrictive list of legitimate aims. The problem, the fundamental problem that isn't addressed by the Secretary of State is, at no point of Sir James's submissions has there been any identification of a justification aimed at the perpetuation of the unequal treatment or intrinsically linked to the difference in treatment. And no answer has been provided to that. That was the approach and the problem that was identified in Steinfeld. That is the problem that arises here. So whatever is said in administrative coherence, that cannot go logically to the perpetuation of the unequal treatment that's accepted exists. Just in relation to, sorry, one more point on SC, paragraph 103, if I may. This is one of the very helpful summary paragraphs. The very weighty reasons is the first point of significance, required to justify difference of treatment on a particular ground, do not necessarily exclude the possibility of a wider margin of appreciation, for example, where historical inequalities are being addressed. That obviously isn't this case, and there is no other, we say, relevant factor that would change the position as being very weighty reasons being required. The second point in relation to common standards, the case law revolves in the light of the development of common standards among the contracting states. Of course, we say the common standard here is the importance of gender identity. It is the recognition of the importance of gender identity. It goes back to Van Cook. And just, I know my Lord Sales asked me the question yesterday, does it matter that here we're concerned with a positive or a negative obligation under Article 8? And I'd said it didn't matter. If I may just, as it were, in the context then of SC, dealing with that common standard, the reason I say what matters is the, as it were, engagement of Article 8, rather than whether it's then posited as a negative or a positive obligation, is to be found in Steinfeld, in the Supreme Court. The reference is at page 779, paragraphs 18 to 19, where before there had been an argument that there had to be an adverse effect. In other words, you had to show some adverse effect. And it makes it clear at 18 and 19 on page 779 that what matters is ambit, as it were. Access falls within the ambit of Article 8, and that's the starting point rather than whether there is or isn't a difference of treatment. So that's why we say the common standard is that Article 8 is engaged, as it clearly is and always has been following Van Cook. If I may, do the discourtesy of the court indeed impress, just to double check if I get the thumbs up to sit down again. I do indeed. Thank you very much. I'm very grateful for your patience in letting me exceed my time.
Not at all.
Thank you, my lord. Thank you, ladies.
Obviously, the court recognises this is an important appeal for the appellant, and it raises issues of wider legal importance as well. So we're grateful for the careful submissions we've received from all counsel, and grateful also to those sitting behind them who've no doubt assisted in their preparation. It will take us some time now to consider the submissions and prepare our judgment, but we'll let you have that in due course. In the meantime, the court will adjourn.